Daniel Schacht with Donahue Fitzgerald, and I'll be talking about trademarks and licensing and rights of publicity for creative artists. And again, my background is with musicians, so I'll be coming at it from that perspective. The roadmap for today, first topic is the right of publicity. Then we'll be talking about trademarks. And then I want to open it up for broader discussion, which can cover, broadly speaking, 3 categories: business considerations, typical deal terms and agreements, and policing your marks, keeping your rights, enforcing your rights, etc. So let's start with the right of publicity. I normally don't like to just read from statutes, but California has a kind of pretty succinct one, which says that you cannot use somebody's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, goods, services, or advertising or selling or soliciting purchases of those various categories. And really what we're talking about are the 2 very important parts of the right of publicity. First, it's what's used. It's basically any kind of personally identifying characteristic. It can be a signature, it can be a voice, it can be basically anything that leads you to identify a person. And the second aspect that's crucial is that it's commercial use. And so I have a few examples here. Ariana Grande, you have her name, obviously. Ari by Ariana Grande. You can see, I don't know if you can see, but around the top of the fragrance bottle is her name as well. You've got her image, of course. Here you have one by Queen Latifah. So it's a stage name, but still qualifies. You know who we're talking about. And that's also use of a name and likeness. And then I have one that's a little more fun.
Do I buy Country Life butter because it's British? Do I buy Country Life because I yearn for the British countryside? Or because it's made only from British milk? No, I buy Country Life because I think it tastes the best. It's not about Great Britain, it's about great butter.
So that is, do people generally know who that is? You don't have to be too old to remember who that is. That's Johnny Rotten. You don't hear his name, but you know who it is. So here we have, again, name and likeness issue. And this is obviously not a U.S. ad, but in international jurisdictions handle this very differently, but generally speaking, most jurisdictions will have similar laws protecting the use of somebody's name or likeness in a commercial manner. And of course, this is done because hopefully this will get people to buy more butter or whatever it is. And I would be very curious if the butter sales actually went up. If you knew that Johnny Rotten was, peddling your butter. So let's look at 2 cases that talk about what happens when you don't get the licenses. The first one is Bette Midler and Ford. So this was a decision where originally let me back up. Let me give you the facts of the case. Ford Motor had created an ad campaign that harkened back to kind of nostalgic songs from the 70s. And they tried to get the original artist to sing on them. And one of the ones who refused was Bette Midler. So they got the rights to her song, and if you know your music copyrights, they licensed the composition. They re-recorded it. They got a voice, somebody to sing, I believe it was her backup singer, who could really imitate her very well. They got this singer to imitate her voice and recreate the song. So from a copyright perspective, they had all the rights. They had the master rights, they had the composition rights. And in fact, the trial court said, yeah, that's enough. You have the copyright. That's, if you're a lawyer, it's federal law, it preempts state law. But the Ninth Circuit said, no, there's an extra element here, and that's her distinct voice. And just like any distinctive feature, you have to get permission to do that. And so the Ninth Circuit said, in fact, that was infringement of her right of publicity. Similar case is Tom Waits versus FritoLay, and in these cases, there's always the hot email that says, "Hey, Tom Waits won't do it, or Bette Midler won't do it," or maybe before the days of email, it was some letter saying, "Can we find somebody who sounds just like Tom Waits?" Basically same set of facts. Tom sued, and he won nearly $2.5 million. So these rights are important. You do have to make sure if you're the one who's using the rights, you have to make sure they're properly licensed. And even though somebody like Tom Waits might earn more damages from their use, somebody like me has publicity rights as well. In fact, it's just, you don't have to do anything to have those rights. They just exist, and they exist for everybody. You don't have to police them. There's no duty to police them or anything. What is different in different jurisdictions is whether they extend beyond death or not. So in California, there's another statute that extends essentially the same rights to somebody who has died for a period of 70 years. There's a famous case with Marilyn Monroe where, if I recall, she was living in California, but for tax purposes, she was a resident of, I believe, New York. And because she was a resident of New York when she died, she did not have post-death celebrity rights. That she didn't retain any, or her heirs didn't retain any rights to her name and likeness. Which, of course, if you're making Marilyn Monroe merchandise and paraphernalia, is a pretty big deal. But important takeaway there is that in California, for example, just because somebody has passed away doesn't mean you can then use their rights. In fact, I represent a few estates where that's part of the job, is to make sure that those rights are enforced. One caution I will throw in here, just because it is kind of part of this discussion about endorsements and the like. Increasingly, the FTC is taking a stand against celebrity endorsements that are not clearly endorsements. And their guidelines are fairly broad on this. All they say is there has to be, if there's a material connection between an endorser and the marketer of a product. In other words, any kind of connection that might affect the endorsement, i.e. somebody's getting paid, or somebody's receiving free products, or basically anything else of value. That endorsement that paid endorsement has to be disclosed. You might do, if this comes up in Twitter, that's why I have that graphic. The Kardashians, I think, got dinged for this. If your client or if you as a artist are tweeting about this great beer, if you got paid for that, or I guess in the fashion industry, if you received product, you need to make it clear. It needs to be obvious from the ad, obvious itself that it's an ad, or it needs to be clearly labeled as a paid endorsement. So this is something, obviously if you're a bigger celebrity, you're more on the radar of the FTC, but this is something to keep an eye on and just to counsel clients on and try to steer clear of violating the law there. So that's a super quick overview of personality rights. I wanted to move on to trademarks. And trademarks are, very briefly, just a mark that identifies the origin or source of goods and services. And it doesn't even need to be a source that everybody understands. It can be anonymous, but it has to be a single source. Typical or prototypical example is the golden arches, right? Whether you like McDonald's or not, that you're going to get a certain burger or a certain shake when you see those golden arches. And the expectation is that is a consistent quality, that you're not getting, something else masquerading as a Egg McMuffin or something. And what kinds of trademarks are there? Now, there can be all kinds. You can have scents and sounds as trademarks, but typically you're talking about kind of three areas. And Also, in one that doesn't get a lot of use in the music world, at least, is trade dress. I think that's probably a big deal in the fashion world, and certainly there's some interesting cases about the color of the soles of shoes. But in the music world, you're more likely going to see names, so Smashing Pumpkins, or pick whatever band name you want to put there, and logos, of course. And just so to clarify on the trade dress, this fake wax is actually an enforceable trade dress if Maker's marked. See trade dress in the music world in instruments. That's occasionally where you see it, but it's pretty limited. And so I was talking about McDonald's as the example, but really what we're talking about is any kind of source of a good or service. And I wanted to use this as an example because just putting something on an object does not create a trademark. Most people would not assume that Nirvana is a great T-shirt manufacturer based on this T-shirt. Right? And this is a common issue that you come up with in the music world and other artists, other similar artists, where they think, well, I got it on a cap, I got it on my T-shirt, I'm good to go, where's my trademark? Well, this is really just advertising a band. And so the USPTO, the Patent and Trademark Office, will generally take the position that this is not identifying the source of a clothing manufacturer. Because if you wanted to know who made a shirt, you would look in the back, right? And there are exceptions, if you have your Izod, does that even exist anymore? Or your Polo, right? You may have a small logo. But really the idea is, who made this? Where is this coming from? And another example, nobody thinks, hopefully, that Donahue Fitzgerald makes mugs, right? This is just decorative. This does not identify us as mug manufacturers. You would probably look here, and there is nothing down here, but this is down below is where you'd expect to see the trademark for somebody who makes mugs in this case. Similarly, I'll just mention that titles are generally not trademarkable, right? Just because you named your album something does not necessarily mean that that's a identifier for a good and service. I've been playing with my kids the Harry Potter game, which is a board game, and they've managed to register some trademarks, but you'll see that they claim characters. Like they'll say Ron Weasley TM, which is an unregistered trademark, which just means they don't want you to use that, but there really aren't any trademark rights in a character like that. It's a literary character. This is not identifying a good or source of a good or service. Another thing that's characteristic about trademarks is they're really focused on the type of good or service that you use. That's why I put a few examples here of the use of the term United. Right? You've got United Airways, Manchester United, United Healthcare, United Way, United Technologies, United Linen and Uniform Services. There are probably a million more Uniteds out there. The reason that this works is because nobody gets confused by this, right? You don't go to United Airlines and think that you're buying a ticket for a soccer game, or accidentally buy a linen uniform when you think you're getting an airline ticket. So as long as the same mark is being used on distinct goods or services, they can coexist. And one of I think the biggest takeaway for artists in particular from this kind of presentation is that trademark is not it's not an ownership statute, really. It's a consumer protection law. It is about customer confusion. And I find personally that artists have a very good natural comprehension of copyright law. Right? They tend to understand that they create something that they possess, and that they generally have the right to tell people what they can and can't do with that art. Right? They understand if I painted a picture, or I composed a song, that's mine, I have a right to it, I can keep other people from using it. Whereas I think, and sometimes I try to apply that to trademarks, and there's always a bit of a disconnect there, saying, well, you can't just own it because you created it, right? Just because you're calling your band United doesn't mean you can stop United Healthcare, United Technologies, or any new company called United just because they have the same name. Now you may, if you called your band United and you were established, all of a sudden United Airlines started to sponsor a music festival. Yeah, maybe you have a point there to say, okay, United Airlines, this doesn't work, because again, the point is customer confusion, right? And if you're fighting with them over this, courts in particularly love actual confusion, right? If you point out, I got 10 emails from fans so excited that my band United is going to play this festival, that matters a whole lot, because that goes to the heart of what trademark law is about, is preventing customer confusion. And really, a lot of these issues go back to, if you're trying to figure out, well, does this infringe, does this work? A lot of it goes back to, does this confuse customers about where these goods are coming from? Can you, yeah. So if he's using a logo, again, when you're talking about using it on a T-shirt,
yes,
then I would say, well, there might be confusion. Is that a cognac? Is that the liquor brand that's selling a T-shirt? Whereas if somebody is performing as an artist, and Hennessy, the liquor company, is coming after him for that, I would say, wait a second, nobody's confusing this artist with your cognac. So again, it comes down to how confusing is this? I probably would counsel somebody like that, not, if you're using a logo, I think there's some issues with that, right? That can be more confusing. Certainly, Hennessy, the rapper, can't go endorsing liquor, right? Or probably even beer. There's kind of a natural zone of expansion or similar related products that he would have to be very, very conscious of, and undoubtedly would get a cease and desist letter the moment he tries to do anything. But again, as long as it's separate, you're okay.
Can I comment on that?
Sure. Right. So, and the endorsement of is also can be an infringement, right?
Right.
Or affiliation with. So
Yes.
it's not merely that.
Suggesting that there's
Right.
an affiliation when there is not.
Correct. So it's not merely that somebody thinks, oh, this rapper is now making cognac, or that it's that there is an affiliation and endorsement.
Mm-hmm.
But without knowing the facts, there's a local band called the Milk Duds. That fought, I don't know who the candy company was, but back when I was playing music, they got cease and desist letters. There's bands that have dealt with using Barbie and videos and things like that, and there's some of it is our First Amendment claims if you're talking about videos and singing about Barbie. But certainly I felt like at the time Milk Duds, it's like nobody's confusing this alt rock band, the Milk Duds, with the actual, I don't even know, what are they, chocolate malt things. But again, it's something to think about, especially if you're starting out, if somebody's starting out in their career and they want to call their band Barbie. It's like, well, do you really want to invite a barrage of cease and desist letters from a company with a lot of money, or would you rather pick a different name and spend your time building your own brand rather than dealing with that? And that goes, I think, leads into the next section of this. Another key part of this, which again is very different than copyright law, is the use in commerce. right? So if Hennessy, the rapper, all he's doing is rapping to friends and family, he's never out, that's fine, right? Especially if his name is actually Hennessy, right? There's nothing illegal about that or infringing. And similarly, if you are just sitting in your bedroom using, thinking about band names or names for your fashion label, that generally you're not going to get trademark rights from that. We'll talk about one exception. The key is that you're actually out there using it in commerce. Another important distinction, sometimes I get artists saying, hey, I want this phrase, and like, that's great, and we can file what's called an intent to use. We'll talk about that a little bit. We can kind of put a marker saying you're going to use it, but at some point you have to use it in commerce, and if you don't have any rights to it. And that also goes to another question that comes up, how long do these trademarks last? And they really last as long as you use it in commerce. So if you think about some of the oldest companies around, as long as they've been using that name, Bayer, or I don't know how, well, McDonald's I guess has been since the 50s, but it can last essentially forever, again, as long as you use it in commerce. What I find interesting nowadays is because so much more music is available that used to go out of print, that means that some of these names that you would expect to kind of go back into the public domain end up kind of being permanent, because as long as you're on Spotify, as long as you're available for digital download, you are using that name in commerce. So it creates a bit of a problem for band names. In fact, one of the last bands I was in was called the Bittersweets. And it turns out there's a band from the 50s that had long since stopped, 50s or 60s, long since stopped doing anything, gigging, releasing music or anything like that, which at the time would have been fine. But nowadays, that band and their old recordings are on Spotify, right, and Pandora. So you kind of have to... Neil's getting coffee for the audience here. So that's just something to consider, that these names are often no longer kind of expiring because so much is still somehow available. And there's a case in, I forget what circuit it is in, but it's a trademark case that basically said, well, if you distribute one bottle of olive oil, that's use in commerce. Right? So the threshold can be extremely low. Another point here is seniority. Who has the rights? Generally speaking, it's always going to be the one who started first, assuming there's continued use in commerce. But if you beat somebody to market, then you have this what's called senior rights, and you will be superior. Your rights will be superior to the junior user. And I'll just mention the intent to use. There are two types of trademark applications. One is based on use. You're already using the mark. You file the registration. You just show that you've been using it. The second is an intent to use, wherein you say, you can kind of park. You can say, I intend to use this, and you have to use it within a window of 2.5, 3 years. And as long as you actually then show use, then your effective start date of that is your date of registration. So just to give an example, we all want to start, a fashion house called, let's pick something trademarkable. California lawyers for the fashion industry. That's too descriptive, but pick some, whatever our name is. Pixie Fashion. So this is a great idea. Before we sink a lot of money into it, let's make sure we get the name, we check, it seems fine. We register what's called an intent to use application today, April 24th, is that right? And as long as we, we get everything up and running a year from now, we show the trademark office that we're actually using it, the effective date is today. So if somebody starts using that same Pixie or related, confusingly similar name, there's a Pixel Fashion that comes out 2 months from now. As soon as our registration is complete, we can go back to them and say, hey, wait a second, actually, we have senior rights. You have to stop. So that's also something that's important, this junior and senior rights. In fact, a lot of these cases that you deal with, disputes center around who did what first. Anybody know who this person is? This is Taylor Swift. So obviously you recognize the great artist Taylor Swift here. Anyways, this isn't a person who's actually, and so I often get these questions, well, can I use my own name? Right? And the answer is, well, you can use it, but not necessarily in commerce. And to me, that highlights, this important part of trademark law, that it's about using it in commerce. So this Taylor Swift actually does some nice photography. There you go. If you want to see Taylor Swift's photography, and I believe he's adding his middle name Taylor Adam Swift to make it a little more clear. But this Taylor Swift could not use his name out gigging. If he wants to sit in his bedroom and write songs and play music, that's fine. But if he's out there performing in public for money, if he wants to market himself as Taylor Swift, it's not going to happen, right? He can't do it. And just to give you an idea of Taylor Swift, I think there's some like 60 trademarks for Taylor Swift. She's very protective. But here's some of the things that she's registered. Key rings, picture frames, cloth bags for laundry, toboggan hats. So if this Taylor Swift decides to do toboggan hats, he better not use his own name for that. He has to come up with a different name. And that's just, it is what it is. There's, you can get into funny disputes, especially representing famous artists, dealing with people who think just because they have a name they can use it. It's like, no, that's not how it works. If you are using it in commerce, you need to kind of make sure that you're not confusing people. If your name is also Hennessy, doesn't matter that your last name is Hennessy. You may not rap if your friend there has an established career and he's out there, even if it's not high profile, right? He's out there first, he's selling records, he's gigging around the country, he's a senior user. Joe Hennessy can't go and then do any kind of music, really, anything that's confusingly related. That's a good point. No. Because the idea of the confusion goes beyond, it incorporates all the senses, right? If it sounds similar, if it sounds confusingly similar, that's going to be a problem. Even if it's spelled completely differently, right? And if it looks similar, it's going to be a problem. If for some reason you decided to trademark a smell, which you can in theory, and maybe your band trademarks the smell of a bar at 2 a.m., I don't know. But if that's confusingly similar, that's a problem. But yeah, the sound, typically it'll be the sound and the look that are the main things that you want to consider. But that's a good question. Yeah, I haven't looked through all 60-something Taylor Swift records, but yeah. And, so there's, what I find interesting too, especially nowadays with the internet where people post, cease and desist letters, is that there's some element of public relations in how you deal with other marks. And certainly, the famous Taylor Swift doesn't want to appear to be mean and cruel to the other Taylor Swift. So, and you'll see, I always like collecting the cease and desist letters that are very well written, that are very respectful, sometimes funny. There's a famous one from Jack Daniels that's kind of very respectful. There's a recent one by Budweiser that when they did this dilly dilly thing, they also did a very kind of funny yet serious cease and desist letter to a brewery. So it's something to consider in both sides. I've had to deal with clients who are facing a letter from celebrity clients versus also representing celebrity clients, where you really have to think about, if I send this, This could be on somebody's blog tomorrow, and you have to consider, what does that look like? And vice versa, if you're getting a cease and desist letter from some lawyer who claims to represent a celebrity, is like, do they really want this out in the public, or can we talk about it in a way that everybody benefits? Yeah. I find that one way around it is to focus on the customer confusion. I mean, again, that's really what this is about. And if you represent a famous band, it's not about, or it's primarily about what the fans want and protecting the fans, right? And if you can phrase it that way, that's at least one way of trying to set the right tone.
I have a quick question
Sure.
about
Can we table that? Because
Yes.
I will be talking about the difference between the
Oh,
registered and unregistered, and then I'll get back to that
totally.
when because it is, that's the main issue with unregistered marks is the territoriality.
Territory, yeah. I think
Yeah.
so.
So moving on from Taylor Swift's many trademarks, let's just talk about how strong a trademark is. And there's certain issues that I find that just don't come up a whole lot. And one is the very intellectually interesting trademark issue of genericide. Right? There's all these fun trademarks like escalator. Escalator used to be a trademark, but if it becomes such a common word that it's used in everyday language, it's no longer a trademark, right? And you can think of things that are teetering on the brink, like Kleenex, or Google recently won. I thought that was one that could have gone either way. To Google means to use, Google was able to convince the judge that Google means to use Google and not to use any old search engine. But these are not, while intellectually interesting, it's not something that comes up, I find, in the music or entertainment field much, if at all. So we'll just talk about generally what these trademark categories are. And this is really a spectrum, but judges tend to line them up into these categories from strong to weak trademarks. So the fanciful, and these are coin terms, they're made up. They have no meaning before being used as a trademark. So Haagen-Dazs is nothing. It means nothing. People, they claim to some kind of Danish heritage or something, but it means nothing. Verizon there's no Verizon before Verizon came around. Exxon it's not a thing, but now we associate it with something, right? I think the Beatles, if you look at it literally, sound-wise, obviously it's a word. But Starbucks, though I think there's a question about whether that's a character in, I think Starbuck is a character in Moby Dick. But still, these are considered very strong. They're inherently distinctive. So if you're brainstorming or thinking about names for your fashion label, for your band, etc., this is the best category to go for, right? Make up a word. This is also why those funny drug names. They're making things up, or car names, right? They're trying to get into this category. The second category, which is also very strong, is called arbitrary. So an obvious one is Apple Records or Apple Computer. What does an Apple have to do with a record or music or a computer? Nothing, right? So that connection is entirely arbitrary. Another one that's kind of fun is Nickelodeon. I found out a Nickelodeon is a early movie theater charging the admission price of a nickel. That's a Nickelodeon. It's not really connected to a children's television network. This is a fun one. Smashing Pumpkins too. You can see I like the Smashing Pumpkins. This one, do people know what this top middle one is? Come on, we're in the Bay Area. Great band, Hieroglyphics. That's their logo. It is, I believe, actually a Mayan numeral for 8, and sometimes used as a symbol for infinity, but it is no direct connection to this great hip-hop collective. Similarly, this is a fun one, Pelobulus. I believe it's pronounced. It's a dance company. It's named after a phototropic fungus that the founder's father was studying in a lab at the time of the company's inception. And the fungus grows on cow dung and propels itself with extraordinary strength, speed, and accuracy. So while you might argue that, well, the speed and accuracy and strength is somehow connected to a dance company, I think a judge would say, no, this is extremely strong protection. And I think you'll see why these are considered strong as we move to the next category. So the next category is suggestive, and now you're starting to get into a weaker category. They're definitely not as strong as the arbitrary or fanciful, but they can still be good trademarks. They hint at the product, sometimes in a clever way, without actually describing it. So one that's not up here, but that's a good example, is copper tone. Right? It suggests what's going to happen if you apply the products and go lie out on the beach. But it doesn't say, it's not saying suntan lotion. Fruit Loops, there's no fruit in there, but it suggests the taste and the shape. Greyhound for a bus, Jaguar for a car, right? It suggests speed, but without, it's not actually a greyhound. It's actually much faster than a dog, but still. 7-Eleven, it's used to be how long they were open. Airbus for airplanes, right? Suggests this is what kind of, you get the concept, right? You think, okay, there's a connection. I think I would put fat beats in there. They're not literally fat beats, but they give you a sense of what this collection is going to be about. Then you get to the fourth. And again, this is a spectrum. So one of the things you'll be arguing if you're in court about this is you're going to be arguing whether Fruit Loops is suggestive or descriptive. I think this is an obvious one. Vision center. What happens here? Like if I were telling you, oh yeah, I went to the vision center. Like, well, did you go to that or did you go just to any plain vision center? They're describing what they are. Computerland. The Barbary Coast Dixieland Band. That's what they do. They play Dixieland. And one of my favorite bands with the world's worst trademark, or at least the worst name from a trademark perspective, The Band. There's absolutely no way they could ever get a trademark for the band. And it makes sense, right? Could you imagine policing that and saying, I'm sorry, you cannot describe your musical group as a band because that's our trademark, right? And so obviously they've had great success, amazing musicians, great songs, etc. But if you were sitting down with them as their manager or their attorney in the beginning, you would say, you guys have to change this. But for better or for worse, they decided to become a famous band with the world's worst trademarkable name. Unregistered versus registered trademarks. So this is registered, unregistered. You may not use the R if you don't have the registration. And the thing about unregistered marks is in this country, you get trademark rights merely for using the mark as a trademark. So identifying a source of a good or service in commerce. If you do those two things, you have trademark rights. And sometimes people forget that. So if our friend Hennessy had actually been rapping well before Hennessy Cognac came out, doesn't matter whether he had a registered mark or not, he would have certain trademark rights. So that's always something to consider. Again, when you're in dispute, you're like digging through records. Can we find evidence of a T-shirt sale? Can we find the flyer for a show that we did in 1982? And the other side's like, well, we got one from 1983, right? But one of the important parts is what we were talking about earlier is how is a geographic restriction. This used to be more important, but I'll use the example of Acme bread, which is, of course, the wonderful Acme bread that you find in the Bay Area, right? There's a San Francisco, Berkeley, that might be it, right? There is an Acme bakery and coffee in Miami. I don't believe that there would be any potential lawsuit between these two based on what I know of their operations, right? Because Acme Bakery here is restricted to the Bay Area, right? My dad, when he comes out, he always goes to Acme Bakery here. He brings some back to Michigan, but he knows this is a Bay Area Acme. And if you're out in Miami, that's a different one. So for unregistered marks, there will be a debate about what the scope of the geography is, what the scope of the territory is, but it is territorial. So I think from what I know of delicious Acme bread, you're going to be arguing about whether it's the lesser Bay Area or the greater Bay Area. But certainly I don't think you'd have a claim to Seattle or Miami. Right? It's just, they don't do business there. Similarly, if this is a Miami company, they might be limited to Miami. And so in the case of a senior unregistered mark, one of the important issues is what's their claim, right? So if somebody gets a registered mark for Acme, they will get, let me back up. A registered mark gives you rights in the entire United States, whether you are using it or not. You will have to show interstate use in commerce to get the mark. But your rights will be from Alaska to Hawaii to Key West. And it doesn't matter whether somebody in Miami says, hey, wait a second, you're not in Miami. Nope, I got a registered mark. It's nationwide. So when you have the clash of a junior registered mark versus a senior unregistered, the fight will be over what's the territory of the senior unregistered mark. So if, again, in this example, Acme Bakery, Berkeley, San Francisco, they've been in, I don't know when they started, but let's say it's been 10 years. And now somebody comes in and registers Acme for bread or food products of some sort. They can tell Acme Bakery, Bay Area, hey, you got to stick to your territory. You can't expand to Oregon. You can't expand to Michigan. But the Acme Bay Area can say, well, we're going to have the Bay Area. We definitely can keep doing what we've been doing, and then they might fight over whether they can go to San Jose or not, right? They're going to say, well, this is kind of our natural zone, the whole Bay Area, and we're doing deliveries down there anyways, so we get to keep that, and since we're doing deliveries, we get to do a cafe there. That's the kind of argument where you're going to have, but that's how those two interact. Does that address the question you had earlier? Yes, and there are some bases for doing that, and I'll just mention one of them, which is difficult, is to prove fraud, right? Because you're supposed to, and this is getting a little bit too in the weeds. That's why I was a little hesitant, but you can, when you actually apply for the mark for registered mark, you say that you have the rights to it. And what sometimes happens in cancellation proceedings is that the person trying to cancel will say, well, you knew you didn't have the rights because you knew, hey, you're a bakery. We're an award-winning bakery. We're known worldwide. You knew that we were here. Therefore, your statement that you had all the rights was fraudulent. Fraud is a high standard to meet. So that's one of the ways, but I will mention another thing that's I'll just mention it because it's kind of interesting, and while we're in the legal weeds a bit, typically in almost every other instance, the statute of limitations will apply to bar claims. What's interesting about trademark law is there are, again, because it's a customer protection statute, it is possible to say that you may not get damages, but because ultimately the court is trying to prevent customer confusion, they will allow, even though you've sat on your rights forever, they will issue an injunction to stop a junior user in this case. And again, this is kind of a legal, we're getting in the legal weeds here, but the point being that because it's ultimately a consumer protection statute, it plays out a little differently in the courts. And so just to sum up with the statute of limitations, the court sometimes will come in and say, okay, this is not about whether you sat on your rights, this is about customer confusion. We can't allow two Acme bakeries in here, and even though you, Acme Berkeley, sat on your rights for 10 years, I'm going to deny you damages, but I'm going to stop the junior user who's been using it for 8 years. And it's a legal gray area, certainly not definite, but again, kind of part of the law that shows you that this is really a consumer protection statute. This is just an example of one typical, kind of registered trademark. And this kind of sums up a few of the things we were talking about. Word mark in this case, so it's the Screaming Jalapenos. This was for different classes, just as background, different classes of goods or services are given. There's an international standard for how they're categorized. International Class 9 includes recorded music. International Class 41 includes, among many other things, live musical performances. So very typical music-related, band-related application. In this case, 1B meant it was filed as a intent to use. It wasn't being used in commerce, but the artist had a business plan, wanted to use it, and we filed. This was, back to the earlier, you can file in a lot of different classes. It'll cost you a little more money each class, but there you go. That's Taylor Swift. Again, just one of them.
And you got to use it. Right?
And then you have to use it, yes. I want to just talk a little bit about, actually, let me back up before we go there. I think one of the things that's interesting is that territoriality has become less and less of an issue because of the internet, right? You are typically marketing and selling all across the U.S. for most things. I imagine that Acme Bakery is really one of the exceptions. I know Zingerman's Bakery, where I grew up, Ann Arbor, Michigan, used to be local, but now they ship all over the country. So bands also, it used to be, well, where are you gigging, right? But now, if you're on Amazon, you're selling, you're being downloaded, you're being distributed very easily all across the country. This type of regionality is less applicable. So certainly that's changed the trademark disputes and made it also more important to kind of vet your trademarks, to clear them, usually to register them. Worldwide, I'll mention a few things. When you're dealing at a worldwide level, you're usually, from an attorney's perspective, you're engaging local counsel in other countries. There's protocols for filing in multiple countries at once, but not all countries use that protocol. In some countries, you just would rather file individually. Most countries are first to file, so it doesn't matter if you're using it, or it doesn't matter that much that you're using it. If whoever goes to the trademark office first and file has the rights. Nowadays, what's really important to know for artists and businesses of all types, if you get to a certain level, you can expect a trademark squatter to have filed for your trademark in China, in other countries as well, but China's a kind of typical example. And I've had that happen to clients where they want to manufacture products there, and it turns out somebody has filed for their trademark there, and they're holding cargo hostage. They're holding a container full of your merchandise, your client's merchandise, hostage. So it does mean that we're in a connected world. There's more and more manufacturing done all around the world. And so you have to kind of be smart about when you hop on that international trademark wagon and start shelling out considerable money. You might be a few hundred, a few $1,000s each time for the different countries to ensure that nobody else beats you to the punch. And that's really it's sort of a defensive trademark, right? A trademark can be offensive in the sense that you are preventing somebody else from using your mark, but it can also be defensive, just so that you're preventing other people from claiming that your mark is infringed. And so one of the nice things about a registered mark in the US, for example, is it's very hard for somebody then to come out of the woodwork and claim that you're infringing their mark. Because 9 times out of 10, you waive the registered trademark and say, no, I registered my mark, and that's the end of that. So it's good to think about these kind of from a defensive and offensive perspective. And this is, I would say it's an unfortunate reality nowadays, but it's just a reality. As you are more successful, you just have to plan for that global perspective and be prepared. And the sooner the better, really, because it's much more expensive to try and undo these things. And speaking for China specifically, they passed a reform of their trademark law, I forget, a year or two ago. It's helped a bit, but you're still at the mercy of whoever filed before you. And I'll just mention a business topic of that too. People often are like, oh, let's license it worldwide. Let's do this, whatever it is. And you have to think, well, can you really afford to do that? You've just granted rights to, I don't know how many jurisdictions realistically. You've indemnified that entity, that licensee, for claims of the trademark. Are you going to go file trademarks in all of those 150 countries or not? And it's interesting, I track a little bit what bands are doing, because technically if you're doing a worldwide tour, from an attorney's perspective, the best thing to do is line up trademarks for live performance in all those countries, but it's just rarely done. But it is something to kind of keep track of. When is that first lawsuit going to come to stop a fairly well-known band from touring by somebody who filed a trademark? So these are just things to put into perspective. I imagine for the fashion industry it's very important, right? Because you've got, aside from copyright trolls, you've got trademark trolls, you've got manufacturing, which technically doesn't need a trademark usually. It's not actually marketing and selling the products necessarily in the country, but you have to be aware that those trademarks are used to hijack, right? By a trademark troll, trademark squatter to try and make money off you. So it's definitely something we see a lot with clothing manufacturers, but any kind of fairly well-known brand or even moderately well-known brand, they will have trademark squatters. So that's my note on the global scope of this. Let's jump to protecting your trademark. I don't want to get too much into details of trademark registrations. One of the things about trademark law is you're supposed to protect your trademark. And you'll often hear attorneys say this. Sometimes they say it to sell their services. There's a truth to it. If you let everybody else use your trademark and you never do anything about it, you have a problem. However, that doesn't mean you have to sue everybody who uses some colorable imitation of your mark. There's a case out there saying, look, you can do what's economically prudent, right? That may be sending a cease and desist letter if that's appropriate. But it is important to know that you do have a duty to police it, right? This is unlike copyright law. Copyright law, there's no duty to police at all. If somebody infringes, it doesn't matter unless you specifically affirmatively gave up your rights. That's still copyright infringement. And trademark, if you let stuff happen, again, it's a customer confusion, customer protection statute. If you are allowing this confusion to happen, it's on you. And your job is to make sure to participate in that process to make sure it's not confusing. Domain names. This was actually one my firm worked on. There's a couple different procedures, but there are processes for going after domain names as well. So that's it's interesting, it waxes and wanes. Now with apps, it's a little less important, but certainly you want to protect your name online, and you want to Another reason to have registered marks, you have more protection when you're going after imposters. You can use, even though the defendants might be anywhere in the world, you can use ICANN procedures to block domain names, to get them assigned back to you. So something to consider. And also goes back to, I think one of the important things is sitting with your client, be it a band or be it whoever it is, early on to establish, well, practically speaking, what do we do, right? If maybe the trademark is clear, but that name is already being used on Spotify. Maybe it's clear, but somebody already has a domain name for something else entirely. So part of what you're doing, ideally early on, is the business team or the management team is getting together and saying, okay, what do we need to get? Not just from a legal perspective, like a registered trademark, but also from a practical business perspective. Let's get all the different domain names that we think matter. Let's make sure that we're on Spotify and Pandora with our name first. And if we're not, let's pick a different name or figure out a way to differentiate ourselves. Oh, this was my experience with it. This was my band, I think I mentioned earlier. This was while I was still in law school. And we had a registered mark. And along came this band, Bittersweet, the breakup. And we did not litigate this, so I think they're both sort of still around. This is my favorite artist endorsement. So I wanted to transition here just to moving on from kind of the basics of what these rights are to how they're dealt with in deals, in merchandising deal. And this is one of my favorite ones. This is the Kiss casket, right? It's unfortunately no longer in production, but if you were a Kiss fan, you could enter the afterlife in your own Kiss casket. And here we are with Gene Simmons with, I don't know why there's ice cold beer in the casket, but there you go. So what are the rights we have here? All right, you can actually see, there's the registered trademark for Kiss. Is this, what do we think this is registered trademark is for? Is it for caskets or not? Probably not, right? Nobody thinks Kiss, after they finish their gig, is going in the back and building caskets, right? This is probably just their mark for music services. And in fact, I did look up, I quickly beforehand looked up, and I did not find a Kiss registered trademark for caskets. What else do we have? We have name and likeness, right? He's there selling, I assume this is from some ad promotion. Gene Simmons is using himself to promote this. I don't know whose signature that is. Is that Ace Frehley or Paul Stanley? Anyways, there's a signature there, and that has to be explicitly licensed or bundled in with probably all four members. There's somebody's face. I don't know Kiss well enough to tell you whose lips that is. Even without the name and likeness on the casket, there you've got a name and likeness in the background and the cutout, right? So they've used the cutout to promote this. That would have to be licensed. Now, of course, whoever's the casket manufacturer would have sewn up all these rights, and had they not, they would have been rather foolish. But here we've got all four members on the casket. So the deal has to be done here probably with all four members, as well as they probably have an entity that controls their Kiss logo. Then, of course, you also have to do the copyright clearances of the photos, etc. But that will be the rights you'd have to license from that. Another question is, I think it's interesting from a business perspective, is this help Kiss or not? I think, sometimes as lawyers we don't always think about this, but is this a good thing or not, right? We've definitely been involved with bands where some might say they do too much merchandise, right? So you have to think about, I think it's kind of funny, and it fits with Kiss, kind of their personality, so I think this is overall positive, and if you can actually get people to buy this, it says a lot about how devoted they are as fans, but it's something to consider. In terms of the other deal points, I'll mention a few. I kind of talked about this a little bit before, territory, right? If you're doing these kind of deals, it's very easy to just say, oh, do it worldwide. But you really need to back up and say, aside from the rights protection that we talked about earlier, right? If you're giving somebody North American rights, are you going to file trademarks in Canada, Mexico, Central America, Caribbean, right? All the different countries there. But another perspective is business. Do they actually do any marketing there, right? Why are you handing out these territories willy-nilly when they don't have a track record? You know, why not restrict it to areas where this licensee is shown that they can sell whatever product you're selling, and then build from there, maybe country by country. And sometimes it also works the other way, right? I think we've all seen the ads like Arnold Schwarzenegger does in Japan only, or Brad Pitt. You know, you get these artists who do these really ridiculous commercials in foreign territories. They don't want to affect their image here in the States, so they do the opposite, right? They just say, you can use my name and likeness, but not in the States. And of course, that doesn't work so well in the era of YouTube. Exclusivity is another thing to consider, you know, pretty typical deal point. Most not every, but many licensees will want to be exclusive, and so you want to be clear about what you're tying up. You know, Hennessy may want to endorse liquor, and the Hennessy, the liquor company doesn't want him to advertise beer, but maybe he says, you know, those are different. I want to be able to do hard liquor with you, but I want an exception for wine, right? These are just negotiation points. It's very interesting because you can often push back on these and really get a sense of what they want, especially now where you're seeing some very interesting companies doing custom vinyl or some kind of internet-related product. And you can kind of push back and say, they might start with, well, we want exclusivity for some broad category of products. And if you push back, you can kind of see, well, what do they really care about? Because what you don't want to do is just give up other possible endorsement rights when you don't need to. One other one I just want to mention specifically, part of trademark law is you must actually have quality control. This goes back to the idea that you have to have a single source, right? If McDonald's let their franchisees do what they want with the burgers, you don't have kind of this quality control, and you can actually lose your trademark rights. So again, from an attorney's perspective, you need to draft these to have some actual, real quality controls, because however it comes up, maybe it's, you know, you're trying to sue somebody and then they go after you saying, hey, wait a second, you actually don't have a trademark. And then in discovery, they find all your licensing deals and realize you don't have any quality controls. You have a problem. So again, this is back to the idea of a customer protection statute. And I thought I would just kind of, actually one other one I wanted to mention dealing with artists is approval rights. I find that to be somewhat different with artists. You really have to know what they care about and what they don't. Some artists, they just, you know, hey, cut me a check, I'm good. Other artists want to see every single advertisement that goes out, some want to see how their image is being used, some want to see everything. And it's legitimate. Whatever they want is really what you're going to have to fight for from the artist's attorney perspective. So that's one thing where I really, you know, I think it's important not to take anything for granted there. You don't want to presume that, well, you did a deal for this before and now this is fine. Similarly on exclusivity, you may want to make it clear that they can do wine but not hard liquor, right? Maybe the artist has a personal reason for not endorsing something specific. I'll just throw up some other deal terms. I'll mention really quickly along morals clauses, also approval. I have some artists who are very insistent that there's a code of conduct for the licensee. No child labor, no the workers, wherever they are in the world, need to have good working conditions. They need to, the manufacturing facilities have to be inspectable if asked, things like that. Sometimes it's done because they firmly believe in that. I think that's my client's perspective. Other clients, you could see, hey, this is a PR thing. I think it's a perfectly valid reason to think, just like, Hennessy Cognac doesn't want Hennessy being arrested for something awful. Imagine your client is endorsing Enron, right? You can always think about a two-sided morals clause, which I will often do if asked to have one for my client. I will say, all right, fine, but if any of your directors or officers gets tagged or gets arrested for anything indecent, we can pull the plug, because we certainly don't want to be associated with that. Who are the parties? I just mentioned something briefly. The rights we've been talking about can generally be freely contracted away. You can assign them to your own LLC. So as you get artists who are kind of further along in their career, that's typically what they'll do. Similarly, they can be put into a trust. They can pass on. And an LLC is actually good for tax reasons. It's also good for control. As we talked about, this is supposed to be a source indicator. You do not want these rights spread out among more than one entity, which can sometimes happen. Usually if somebody dies, and it gets passed down to multiple heirs. I just mentioned very quickly business model. I mean, the KISS casket, it's kind of interesting. Is that an existing company? Did KISS get equity in it? Is this just a licensing deal? Did KISS get, $200 from every casket? Did they get 10% of the company? Did they create? It's unlikely they created their own company, but maybe. Not, but possible. An artist may say, hey, I really believe in this. I'm going to do this from the ground up. It's a possibility. More likely they will be in an equity share, if you want to structure it that way, and that can have a great benefit. It's certainly a way of capturing the upside for what an important celebrity brings to the table.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.